morning, everyone. Thanks for coming out to part 2 of our estate planning series. We do this every October. I believe it's Estate Planning Week nationally, so good timing for all of you to be thinking about this important topic. Last week we reviewed powers of attorney, healthcare proxies, basics of a will, and all of the details around all the decisions you have to make about those issues. And we did record that session, so if you missed it, we'll be putting it up on our YouTube page soon, so watch for that. Today we're very happy to have Christine Szpet here with us from Finger Lakes Attorney, FLX Attorney, and she specializes in the topic of aging in place and long-term care planning. And so that's really what we're going to focus on today. So thank you, Christine, and her assistant, Kaylee, is here too. Their office is out in Hopewell on 5 and 20, so right here in town, which is very nice. So I'm going to let Christine make her presentation. Just housekeeping things. There is a restroom right outside this room to your right, and we do have some coffee and tea, so feel free to help yourself there. Thank you very much.
Good morning, everyone. My name is Christine Szpet. I'm an attorney that's been practicing for nearly 10 years, and I just recently started my own firm, Finger Lakes Attorney PLLC. As Maria mentioned, we're right on 5 and 20 here in the town of Hopewell. I focus my practice on estate planning and long-term care planning, estate administration and probate, and elder law. And I feel that all of these issues are intimately connected, that it makes sense when you're thinking about estate planning to think about long-term care and how you plan to take care of yourself and your loved ones and afford the rising costs of healthcare. So that's going to be the focus of our discussion today. I have materials that'll give us a little bit of a background on long-term care planning from the estate planning perspective, as well as the estate administration and probate perspective, and then we'll deep dive into what long-term care planning really is. There'll be ample time for questions, and it likely makes sense for us to do questions as we go along, as opposed to saving them all at the end. So if you have a question, raise your hand, let me know, and we'll just start our discussion there. All right. So, I think the very first thing to understand is what is an estate. Oftentimes, people assume that if they pass away, they're going to have an estate, but that's not actually true. You only have an estate if you pass away owning assets in your individual name, or things that do not have any kind of designation, like a beneficiary designation. So, the legal process for transferring those assets from your individual name after you've passed away is what is known as either an estate administration or an estate probate. And the last will and testament, if you have one, is what would trigger an estate probate. So oftentimes I sit down with clients and they're like, wait a minute, I have a will, is it going to probate? Yes, because actually having the will is what triggers the probate proceeding. Probate is the legal process of proving the validity of your will. Was it properly executed? All the time I get questions, I made up my own will, or I downloaded a form online, and I had it notarized. And those nuances of how the will was actually signed, whether or not it was properly witnessed, was it witnessed in the presence of an attorney, those are some of the things that proving the validity of a will turn on. So that is what is an estate probate. And if you pass away without a last will and testament, then the name just changes. It's known as an estate administration. It's substantially the same legal process. The objective of the person who's petitioning the court, they're seeking legal authority to be able to, as a fiduciary, transfer assets from your individual name to whomever is either your beneficiary under your will or next of kin for the default set of laws that New York State has for us. So an overview of that process, I think it's really helpful to understand we need court approval, right? So you can't just after someone passes away go in and take care of all of their affairs, without any legal authority to do so. So the person who is seeking to be responsible for that petitions the court. They make affirmations to the court to let them know where they live, the relationship that they have to the person that passed away, whether or not there was a diligent search that was done for a last will and testament, if they found one or not, and then they identify who is legal next of kin. So again, oftentimes people think, well, I have a last will and testament, I've left out, some of my family members. Do they even have to know? Yes, they do. The law protects those legal next of kin by class. So what do classes look like? That could be your spouse, that could be adult children from a prior marriage or a current marriage. It could technically go even further and further out on the family tree depending on your circumstances. So what we want to do is get the court approval to make sure that we have legal authority to be able to act. And the court reviews the petition and the paperwork that is submitted to them and then issues what are called letters of authority. And that could be letters of administration, if that's what you were applying for in an estate administration, or letters testamentary, if that's what you were applying for with a last will and testament. And when those letters are issued from the court, it begins a 7-month creditor period. So for 7 months from the date those letters are issued, creditors have a right to step forward and lay a claim to the estate. They can technically lay a claim after the expiration of the 7-month creditor period, but there's liability back to the fiduciary if they go ahead and distribute out assets from the estate to beneficiaries, and now suddenly the estate is insolvent before creditors have had an opportunity to make their claim. So what does that mean from a really practical standpoint? It means we have to hold an estate open for at least 7 months worth of time. Typically, an estate will actually take somewhere between 8 to 10 months to facilitate, sometimes much longer depending on the complexity. Was there a business involved? Are there tax returns that need to be filed in the following year? All of these things really determine, the length of time. And then also I've found in practice the initiative of the person who's handling the estate, right? Because they have all of these administrative tasks. So at the end of the 7-month creditor period, the court requires that an inventory be filed with the court. They want you to report back. What did you find? What kind of assets did you discover? And, oh, by the way, if you had any firearms, what firearms, were discovered in the 7 months that you've had your appointment? And so they require this inventory of assets and this firearms inventory to be filed with the court. The firearms inventory is also filed with the Division of Criminal Justice Services in New York State. And it's a reporting obligation that the fiduciary has when it comes to the estate. And then after that 7-month period, there might be still more business that needs to be transacted. Maybe there's a home that hasn't sold yet because it was the wrong season, or there was some kind of hiccup with a beneficiary designation and an asset's taking longer to get distributed into the estate. But that's where essentially the administrator or the executor is dealing with those affairs.
My question is, when you talk about an inventory, how detailed, if you have a house and contents of it, how detailed is this inventory?
Great question. That depends on the attorney practicing. It has been a long-standing practice that inventories would offer a lot of detail, like specifying specific assets and identifying where they were held. It's more common nowadays that just the dollar amounts are reported. The court is truly seeking to understand the size of the estate because it is connected back to the filing fee that the petitioner just assumed would be in the estate. Sometimes there's a discrepancy between those. Like, for example, if you think that something's going to be an estate asset and it turns out not to be, or vice versa, you assume something's passing outside of probate and then it turns out, oh, it actually needs to move through the estate. So nowadays what I see most common is actually just a general inventory that's categorizing dollar amounts with respect to those assets and not very many details at all. Where the details come in is the informal or formal accounting that is done to whomever is either a beneficiary or potentially a creditor of the estate. And this is really necessary in order to be able to close out the estate. So before, a beneficiary just takes their check and cashes it, they want to understand, well, what came in through the estate, what expenses were there related to the administration or probate, and maybe they have questions, right? They want their sibling to, explain to them why this dollar amount was spent on this expense. And oftentimes there are just questions in how things are handled, right? How did you determine what the sales price of the house would be, after mom passed away? Things like that. So the accounting process gives beneficiaries the option to then raise any questions or concerns surrounding the estate proceeding altogether. Go ahead.
Those may not normally apply in New York State a whole lot, because that's what my friend told me. A living trust, what is that? I'm sorry, a revocable trust, that's the word I want to use, revocable.
Great question. So trusts are a testamentary substitute, which eliminate the need for probate, and that's our very next slide, and we're gonna get there. And we're gonna actually have a very substantive discussion on trust today, because it's a critical piece to long-term care planning. So I'm glad you're already thinking about it. The last thing I just want to mention is the estate only closes after all assets are accounted for and distributed, right? Because if not, what ends up happening, we have to reopen the estate, and we don't want to do that. We can, but it's just more paperwork and unnecessary. All right, so eliminating the need for an estate. This is a concept that I talk about with every person who comes into my office. When you complete that questionnaire, there's a financial component, and the reason that I ask you to provide that information is so that I can identify, just by looking at how your assets are held or titled, where you can eliminate the need for probate. Because again, an estate is not required. If you do proper planning to make sure that all assets are either jointly titled or held in trust or have beneficiary designations, we can eliminate the need for an estate. And the reality is, that's the simplest, most effective way to get your assets to where you'd like them to go. It's really difficult for someone to contest a beneficiary designation when you've had it on a life insurance policy. But someone can contest the validity of your will pretty easily. So one of the best examples that I have for this is bank accounts. Most people do not know that you can put a beneficiary designation on your bank account. So I'm literally talking about your checking account, your savings account. You walk into the bank branch wherever you bank, and instead of going up to the teller, you sit down with one of their representatives and you explain to them, I'd like to put a payable on death designation on my account. And it's usually a one-page form where you complete the person's name, address, social security number, and then you sign it and give it back to the bank. And I always tell people, when you do this, keep a copy for yourself. Save everyone the headache of trying to figure out what you've done, right? And you should be doing this in lieu of jointly titling accounts with, for example, one child. So I think the most common mistake that happens is people, think about, okay, well, if I can't write checks, I'm gonna have my oldest daughter be on the bank account with me, and she's gonna be able to write checks for me. And while that thought process, you're thinking in the right direction, right? Like, we need to do some planning in case you're not able to write checks for yourself. Adding them as a joint account owner completely changes your estate plan, because then what happens is, at your death, your oldest daughter is entitled to 100% of that account. And maybe that wasn't your intention, you have 3 children. And so you tell her, well, when you get this account, I want you to split it 3 ways, and you keep a third, and your siblings each get, their third. And now you're asking her to gift funds after you've passed away, right? It doesn't seem like a gift, but that's actually what it is legally. And you're relying on her trustworthiness to do this. And I have had people swear up and down. My oldest daughter would never, ever, ever, ever do anything to, not give what I've asked her to give to her siblings. And then the oldest daughter goes in after you've passed away to her own attorney, and the attorney says, no, you just own that account. And she says, really? Yeah, it's 100% yours, and you're actually gonna have to gift those funds back to your siblings. And she starts thinking about all the things that she did for mom to make sure that, the checkbook was balanced and all the appointments that she took mom to, and then everything else that she did to take care of her, and the account's hers, right? And this is that solution to making sure the account actually gets where you want it to go, to your 3 children instead of just to 1. And there are other documents that can be utilized to solve your check writing problem. So that's the basic of estate planning. And I don't know how many of you attended the previous presentation, so I'm just going to give a quick little refresher here on basic estate planning, because everyone should have this. And it's also pretty critical to understanding the bigger picture discussion on long-term care planning. So when I think about estate planning, I think about planning for both life and death. I think a lot of people just think about planning for death. But part of estate planning is thinking about what you're gonna need if you, for example, are incapacitated. So what's incapacity? Well, incapacity could look like what most people think about, dementia or Alzheimer's, right? But it could also just be a temporary event of incapacity or unavailability, right? Like, you're going in for surgery and you need some bills to be taken care of and be paid while you're, going through short-term rehab, right? So when that happens, there's really 2 documents that are pretty critical while you're alive to have in place so that someone can make decisions for you. For healthcare decisions, that's a living will and healthcare proxy. And the living will component of the healthcare proxy is an advanced healthcare directive, which basically states what you would want to have happen if there was a situation where you were incapacitated, unable to make your own healthcare decisions, and now someone has to make those decisions for you. And maybe there's a situation where there's no hope of your recovery, right? And you're asking your agent to decide, well, what do we do? Are you going to receive life-sustaining treatment or not? And the healthcare proxy component of that document is the actual appointment of your agents. And so you should be appointing a primary agent, and then a successor agent, and sometimes even an alternate successor agent to make sure that you have a sustainable plan in place just in case someone's unavailable. Go ahead.
Sorry to interrupt.
No?
Will these copies of these slides be available to us at some point?
I don't make the slides available only because long-term care planning, the information is constantly changing. And I mean, they're by the month in terms of the rules that surround Medicaid applications. But what I do, and this will be at the end, I meet with people and then I provide this information in our initial consultation. So you get the opportunity to go over all of this again when you sit down to talk with me about your specific situation. So the presentation itself will be available through the Wood Library online through their YouTube channel. There is last year's presentation that's still available online you can watch, and then this year's will be posted in just a couple weeks too. You're welcome. All right, hand in hand with that healthcare proxy is a power of attorney. And the power of attorney is for financial decisions. So this is that check writing power that I was talking about. You want someone who is able to step into your financial shoes to make sure that things continue to operate even if you're stuck in a hospital bed in rehab. And a financial power of attorney is an incredibly powerful document. I mean, literally someone can sell your house, close your accounts, empty them, take out loans in your name, right? Make gifts of your funds. So when you're thinking about, okay, who am I gonna have serve in this role? It has to be someone you trust 110%. And there are some safeguards on creating a power of attorney and then having the appropriate people have, for example, a monitor in place. I had a set of clients who had 4 children. 2 of them would be serving as the agent, and the other 2 would be monitors on the account. Great idea. You can have, everyone be able to pull financial records and hold everyone else accountable to make sure that money wasn't being spent inappropriately. So there are safety mechanisms that exist, but a lot of thought has to be given into creating these plans. You know, too often people are like, well, I don't want my one kid to feel left out. Well, does your one kid have any semblance of how to do an accounting? Or, you know, enjoy actually looking and understanding how money is invested and what is right for you specifically, right? That you're not aggressively invested in the market when you should, you know, be conservatively invested. That's the power of attorney's role, is to consider what is in your best interest and how do I handle your finances and that. And then keep your finances separate from their own, right? There should be no commingling of funds. And since it's such a powerful document, we want to think about all of those things long before we're in that hospital bed. Because if you wait until there's a crisis situation, inevitably there's panic, and then it's not as clear of a thought process in terms of what you need next. The last document that's part of a basic estate plan is a last will and testament. And the question here for a last will and testament is, really, does the default set of laws in New York State apply to your situation and work for you, or do they not? So what does that mean? Well, most people assume that their spouse would inherit 100% of their assets at their death. And that's actually not true. What ends up happening is that the spouse inherits the first $50,000 and then 50% of the remainder. And the person's children inherit the other 50% of the remainder. And the reason the law is written like that is to not inadvertently disinherit children from a prior marriage when you're married on your second or maybe third time, right? We want your spouse to inherit, but we also want to make sure that your children inherit too. Or at least that was New York State's thinking in creating the default set of intestacy laws that control over a situation when there is no last will and testament. So the reason that people put wills in place, other than everybody talks about you need a will, you need a will, you need a will, is because they're actually trying to change what the default scheme says. Meaning they want to leave everything to their spouse, and then after, you know, both spouses have passed, then leave everything to their children. That's the most common. You know, and it's different for different generations, right? So when you have adult children, we're also thinking potentially about minor grandchildren. But in younger years, you know, people are thinking about their own minor children and planning for them. And this is one place where trusts can be created. And these are called testamentary trusts, different than what you asked about living trusts. These are trusts that are created under your last will and testament and operate as a contingency, meaning if the conditions are met, then this trust will spring into effect and be created. But if not, then it just lapses. So what could that look like? Well, I leave everything to my spouse, but if not to my spouse, then to my children, and then two critical words, per stirpes, which means to their children too. And if one of your children passes away, leaving children surviving, their, let's say you have three, 1/3 share goes to their children, but we've created a trust for them. So those minor grandchildren aren't receiving outright. Because we don't ever want minor children receiving outright. Go ahead.
What constitutes a minor child?
Under the age of 18.
Okay.
And that's where the guardianship laws come into place. So essentially, if someone does leave something to someone who's under the age of 18, and this could be any asset, it could be a beneficiary designation. I often find this with like young parents. They like get so excited that they just had their new baby that they name their baby as the contingent beneficiary on all their accounts. Triggers the need for a guardianship. They really need a last will and testament to make sure it goes into trust for their child as opposed to into a guardianship proceeding, which is supervised by the court and requires the funds be deposited into a bank account, essentially not being invested at all, to safeguard those funds for that minor child, to ensure that they receive something at the age of 18. Whereas, if we create a last will and testament with a trust for either minor children or grandchildren, then those funds can be invested and then they can continue to grow. And the trustee can be responsible for determining what kind of distributions are being made and then making sure those funds get to those, you know, minor children or grandchildren at the appropriate ages. Go ahead.
What about
I guess it depends on where you want to leave your assets to. So the next, class of beneficiary would be parents, but if not parents, then siblings, and if not siblings, then nieces and nephews, so it follows the family tree. But oftentimes then you would absolutely want to have a last will and testament, or eliminate the need for probate and make sure that those funds go to where you want them to go. All right, so the basic estate planning is really important to understand the foundational building blocks for long-term care planning. Because in my opinion, if you have a basic estate plan, but you haven't considered long-term care planning, you're missing a big piece of the conversation. And this has been part of the conversation for decades. It's not something new, but it's something that's just being more openly communicated about, especially after we have seen the rising costs of healthcare and the cost of nursing homes being astronomical. And so then we start to think about okay, well, how am I going to plan for myself? And what are we going to do if one of us needs care, sooner than another? And I always explain this as the goal is not to get into a nursing home, but nobody wants to be in one. I don't know if you've walked around for other family members, but they're really not the place you hope to go. You can go there, hopefully for a short term and then return home, right? But the goal is really to plan how you're going to be able to sustainably live. So the more thought that you give to this in advance, the easier this planning becomes. Because if you require, advanced levels of care, then you've already, done the legwork in terms of how it's going to be paid for, and then asset protection and making sure that at least some of your assets gets to whomever you'd like to leave them to. So aging in place is what I explain is basically staying in your own home, right? This is the best alternative that you have. But there's a few caveats to that, and I'm going to explain that a little bit more in the slides to come. But the goal here, and from my perspective, having talked to so many people, you want to be able to stay in a place that you're comfortable for as long as possible, right? You worked your entire lives to pay off that mortgage. You have your home because you actually wanted to live there. You've made it your own. You've done improvements. And from my perspective, the cost is often lowest for you to be able to age in place than for you to go anywhere else and receive care. There are things that you may want at home that cost a lot of money, but there are also things that probably you can readily afford, but maybe just haven't taken that next step in terms of getting to. So I like to think about aging in place in terms of, okay, well, what's going to keep you at home for as long as possible? I have clients who love riding their John Deere, right? That's their enjoyment. They spend, hours mowing their acres, and by all means, do that. But there's going to come a point in time where maybe mowing those acres for hours on end is actually not possible. And so then what happens then, right? Is there someone you're going to hire in to come and mow, the 10 acres of field that you have, right? If you don't do any planning at all and you say, I'm just going to die in this home, right? The reality might come that actually you can't stay there and you can't afford to upkeep it, and so now you actually have to sell it instead of being able to do what you wanted to do, which is die in that home. So we have to figure out how some of those services are going to be paid for. Some of them, like lawn care, right? That's privately paid. You hire someone to come and do that service. Other things might actually be covered by different grant programs that exist in the community. Others might be covered by Medicare. So I had clients who went out and said, we have this beautiful home. It's a gorgeous log cabin, but its biggest problem is that there is a steep set of stairs from the garage into the house, and there's no way to get into this house without taking a set of stairs. So we looked, we talked about what other options there would be. Can you sell that home, buy a single ranch home where, there's no steps available? And they proceeded to go on a search for the next year for their ideal ranch home, and they looked at everything that was possible that came up on the market, and they just couldn't find anything in their area. And so what did they do? they went back to their original problem, that steep set of stairs, and Medicare actually paid for a ramp to come in, chairlift, I'm sorry, like one of those that like gets installed on the side rail and then like would lift you up. Did they need it right then? No, which is great because it took about 6 months for them to navigate all the steps and coordinating the installation and the payment, right? But it's there for them when they're ready. That's what I'm talking about when I say thinking about aging in place and what you're gonna need. Because every person's situation, especially in this community, is unique to them, right? I haven't found 2 properties that are the same. None of them pose the same challenges. There are some similar themes, right? But modifications that can be made that would save money over moving to independent living, assisted living, or nursing home care, which are the next few levels. So when you're thinking about what's sustainable for you long term, like you might already know, like, oh, there's no way I can modify my home. Absolutely not. Like there isn't a way to turn, you know, the half bath that's on the first floor into a full bath. There's no way for me to have a bedroom on the first floor. I'm living in, you know, the 4-bedroom colonial I raised my children in. Like when that happens, then immediately you should be thinking, okay, well, you know, what are my options then? And selling is one of the best options that you have, especially in this current real estate market. There is incredibly low inventory. And most people don't even realize the asset that they're sitting on, right? Because you bought your house maybe 20 or 30 years ago for $60,000 or $70,000, and it has continued to appreciate in value. You've seen the assessment that the town gives you, right, to pay your taxes, but it's likely worth much, much more, especially if you've done any kind of improvements over the years that have somewhat kept pace or are willing to do those improvements to bring it up to what it needs to sell in the market. I have a background in real estate. I've watched the real estate market. It has been incredible to me to see cash offers, $100,000 over asking on homes that there is no business being, you know, 17 offers on. But with such low inventory, that's what's happened. We have a seller's market. And I thought, okay, interest rates being astronomical, we're going to deter these first-time home buyers. No, they're so desperate, they'll pay 9%, right? And then, you know, they hear the stories of your generation that's like, well, in my day, we paid 17% back like in the 90s, you remember, right? So it's still happening that buyers are in the market looking for these houses and they're looking for the home that maybe isn't right for you, but's right for them. And we need to have this kind of turnover in the market. If your home is sustainable for you to live in, it just needs modifications, then do that, right? Because inevitably, even though you're gonna sell your home for more, you're gonna pay more to buy a new home, right? And that only works if you can sustain the increase in the taxes that's gonna come from buying a new home at a higher purchase price. And so those are calculations. You can actually have someone who is familiar with the industry, right? Like a good real estate agent or broker can actually run those numbers for you and tell you what your house is gonna be reassessed at. Same for a mortgage lender. They can very easily run those numbers and give you a clear picture of what you'd be looking at. But if you think, okay, well, we could just make a few modifications, or I'm already in a ranch, what are those modifications? Those are a lot simpler. They're like grab bars in the bathroom, right? So that if you step out of the shower, you have something to catch onto if you slip and fall. Or help buttons, you know, that are like positioned throughout the house, so that way if you're not walking around with your cell phone, that there's maybe a way to access, you know, care. Some of these are even like silly to think about, right? Like night lights in the hallways, right? When you're like get disoriented because you're getting up in the middle of the night to use the bathroom, but not able to find your way back easily. What ends up happening for a lot of older folks is something like medication. Interference, you're not feeling well, you get sick, your medication's been working for you, but then you have a new problem and then you go to the doctor and there's new medications. So it's really easy as you're navigating the healthcare system through your primary care doctor and then whatever, you know, cardiologist or rheumatologist you're seeing, and they're prescribing different things, for you to get confused along the way, mix medications, maybe they have interactions, and then for there to be some kind of event, like you wake up in the middle of the night and slip and fall and hit your head. I also like to think about, what kind of tools we can use, right? Because technology is our friend, even if you hate it, right? It's there for you. There are medication dispensing tools where you can put 60 or 90 pills into a machine and it'll dispense daily for you what you're supposed to take. That works really well if you yourself get confused by how many you have to put into the pill bottle, or you have this like really onerous routine around medication dispensing. Even like watches, Apple watches, Samsung watches, they have fall detection on them now. In my opinion, there's really no reason not to have them based on what the cost is compared to the benefit. So thinking about, can you embrace some of these, pieces of technology to help you age in place? Because that's the goal. You want to be able to stay where you are for as long as possible. I have literally had people who are so stubborn, they need a walker, they don't even want to use their walker, right? Because to them, using the walker is like the limitation on their freedom. But then to me, I think about, well, a wheelchair is a limitation on your freedom more than a walker is, so use the walker and stay out of the wheelchair, right? And then do the physical therapy that rehabilitates you so that you can get rid of the walker. But we all have our own, stubbornness around something, and so you have to figure out where you feel comfortable. And sometimes it's the stories of your friends and your neighbors that help you, move along and really realize like, yeah, I can use that walker. But oftentimes it's just you getting in your own way. So the next level of care, if you're not able to age in place, is independent living. And there's only really a handful of true independent living options, like for example, apartment complexes for seniors. Those are fairly common in our area here in this county. Or 55 and up, which are more common like in other places, but I see this as like any place that has an HOA, right? Like those tend to be inhabited by people who are 55 and up and want the convenience of someone else making sure that the lawn is mowed, the driveway or the sidewalk is plowed, and that, they don't have to take care of these little nuances that exist. So independent living can also look like, part of a larger community. There are communities both here locally in Monroe County where there's an independent living component, there's an assisted living component, and there's a nursing home component. And we call these continuums of care, where you can access care at whatever level you need to enter in at, but then progress to the next level of care. The tricky part is they typically come with an added cost, sometimes an upfront buy-in cost, which can be several $100,000, or annual or monthly maintenance fees that are ever increasing, right? Which makes it a little difficult when you're on a fixed income if you don't have other resources to support you. On average, I describe this as $1,000 to $3,000 increase over whatever your monthly housing expense is, but it really just depends on exactly what form of independent living you found. Assisted living is the next level of care, and this can still look like living in your own apartments, but in a common building with shared areas. And oftentimes, this is for someone who needs daily check-ins, right? Like someone to come through and make sure that their medication is being dispensed or that they're getting to meals or activities. They can be small, in size or much larger. And there are levels of care. So sometimes you can buy-ins for certain services, but not all of them. Like up to 3 meals a day, assistance with personal care, housekeeping, laundry, etc. Whatever the case may be. And then, your dollar amount increases the more care that you need associated with your assisted living. One benefit of assisted living facilities is that they often have social activities and, planned recreational activities, which, it's funny to talk about because it's like, we thought about these things for our kids, right? Like camp, it's like adult camp. And they have like, craft activities and music, but some people really enjoy that. Honestly, I found after someone loses a spouse and maybe they're not so interested in preparing meals, it's kind of nice to have your meals prepared. Other people really hate the idea of forced activities. They're like, I bought my house, you know, on 15 acres so that I didn't have to talk to anyone. I don't want to go into an assisted living facility, right, where now you're going to ask me to do like arts and crafts with, you know, Jane from down the hall. It really depends on your personal preference, right? And this is why I go back to aging in place, you know, the best option we have. Assisted living gives us some more options if you can't stay at home. Nursing home, right? Last level of care. And this is really intended to cover 24/7 care. There are facilities that also have specific units for memory care. Here, now all of the medical care is included in the cost. And this is where the cost essentially is astronomical. It's almost impossible to think about, but it literally is $15,000 to $20,000 a month. And when you have nursing home care, typically someone is in a nursing home facility and not returning home. And usually the average stay in a nursing home is 2 years, namely because someone passes away after just a few years of living in one. And if you've ever really visited nursing homes, I mean, they run the gamut in terms of quality of care. There are some really good facilities that have 4 and 5 star ratings, but most of nursing homes, you know, fall between 1, 2, and 3, and it really depends on whether you're privately paying for your care or you're using Medicaid to pay for the cost of your care. And so you don't want to be in a position where you need a nursing home, you know, and you haven't given any thought to how it's being paid for. That's actually the worst place to be in when you're in the hospital, you know, you need short-term rehab, but maybe it's gonna take longer than a month for you to stay and rehabilitate the hip you just broke. You wanna know that you have a plan in place. Because thinking about it in that hospital bed, when the social worker comes to visit you and they give you your choices of facilities, and you know, have your adult children surrounding your bedside, and they're looking at you and saying, you know, I just Googled this one and it has a 1-star rating. Maybe we should keep looking, and the social worker's like, this is the list of available beds, right? Not ideal. So this is where long-term care planning really comes into play. We want to know that you have a plan in place should this scenario arrive. Does it mean that you're going to a nursing home? Absolutely not. It just means that you planned just in case. All right, so here's just a quick snapshot overview of what I was just talking about. Aging in place versus independent living versus assisted living versus nursing home care. And again, I'm showing you, you know, cost increases, right? So current cost, you average, you know, $1,000 to $3,000 more for independent living above your current cost, average $3,000 to $6,000 more for assisted living above your current cost. You know, nursing home, you average about $15,000 to $18,000 more above your current cost. And then how are these paid for? So aging in place, you either privately pay for people to come and support you, or you can use community Medicaid if you qualify to have caregivers come into your home. Independent living, private pay only. That's the only option there. Assisted living, there's private pay and long-term Medicaid available, but there's really very few facilities that accept Medicaid for assisted living. And I can go into a whole presentation on that alone. Nursing home care, private pay, or long-term care Medicaid available. And most people will privately pay for a nursing home for a very short period of time, if at all, and then have Medicaid pick up the cost of the care. All right, so I'm throwing around different terms, and people often get confused between Medicare and Medicaid. So this is your little refresher between the two. So Medicare is your health insurance, right? What you have with your Part A, Part B, that's your Medicare, your red and blue card. And it covers all of your insurance needs, right? So that hospitalization from your slip and fall, Medicare is covering the surgery, right? And it's even going to cover a short portion of your rehabilitation. It covers short-term rehab. After the Medicare, you know, codes have all been run and they determine maybe you're not rehabilitating at the rate that you should be, or that you no longer need short-term rehab, you might need to privately pay for care or apply for Medicaid. And Medicaid is what you're thinking. It is an income limited and resource-based program that covers the cost of long-term care facilities. But what does that mean? You basically have to be impoverished to qualify. And I have, that difficulty in saying that, right? And you need to be impoverished to qualify because there are millionaires who will qualify for Medicaid. And it actually turns on how your assets are held, not how much you actually have. Because there are certain assets that are exempt. And there are nuances to those exemptions. So it's really important to understand Medicaid isn't just for someone who has nothing, right? Because immediately you're like, well, I don't want to be impoverished. It might just be that your assets are structured in a way where you'll qualify for Medicaid tomorrow, and we need to protect some of the other things that you have to make sure that when the time comes, those will be protected to be able to pass along to the next generation. And then I mentioned in the last slide, that there was Medicaid to pay for caregivers coming into the home. That's community Medicaid. And then there's Medicaid for nursing homes, that's chronic care Medicaid. So those are specified out. And then there comes in the planning. And from the planning perspective, I've broken this out into two categories. There's what I call crisis planning, because we have no time, less than 6 months, before you need Medicaid to pick up the cost of your care. And then there's advanced planning, where we have more than 5 years. And without question, I think advanced planning is the route that everyone should go, because it's a lot easier to plan with time than it is to plan in a crisis situation. But ultimately, it really depends on your situation. Some people will not plan, right? Because they're gonna die in their home. So crisis planning is still available to them, so I'm going to touch on it because I think it's important to understand what it can do for you, but also what its limitations are. And then we're gonna really focus in on the advanced planning because that's the bigger portion of where you maintain control in deciding how you want to plan and how much you want to plan. All right, so in that crisis situation, and you're going to have to bear with me on this explanation, there are really, two strategies. Either you're already close to those thresholds that are set to qualify for Medicaid, so you just need to restructure assets and spend down to the acceptable limits, or you're gonna do what's called note and gift planning. And this is planning that is done by a subset of attorneys that have focused on this practice area. They are experienced in doing crisis planning. This is not something that, any attorney can work with you on. I would most certainly pick someone who is a long-term care planning, elder law attorney who does crisis planning. And what it is actually a way to preserve 50% of your remaining assets that would otherwise need to be spent down towards the cost of your care to qualify for Medicaid. And it's very specific in terms of calculations, which means you need full disclosure. They will require that you provide everything that would be necessary for you to be approved for Medicaid, which is 60 months worth of statements on every bank account, retirement account, life insurance policy, anything you own, right, that's gonna be treated as either income or a resource for Medicaid. And they do these calculations in advance of the application to determine how much an excess resource is that you have, and then what can they do in terms of making a gift and making a loan to be able to cover the penalty period. So to take one step back, anytime you gift assets, it carries with it a penalty period for Medicaid. Currently, the penalty period is 5 years. There's no guarantee that the penalty period won't change. And in fact, historically, we've seen it change. It used to be 3 years many years ago. Now it's 5. In the future, it could be 7 or 10. That's for chronic care Medicaid. Very similarly, on the community Medicaid side, there used to be no look-back period. There is a pending 3-year look-back period going to be imposed, we're expecting in 2025. So the gift carries that penalty period. So if you gift any asset, right, because immediately people are like, all right, I'm just gonna deed my house to my kids. That's a gift, and then you have to run the look-back period of 5 years. Depending on how much that gift was, there's actually a calculation that's done. So if it's the regional rate for the area, that's like a number they give us, let's say it's $15,000. And then the gift you make is $15,000. It's gonna carry a 1 month penalty period for Medicaid. You need to privately pay for 1 month of your care before Medicaid will pick up the cost. Obviously, you can multiply those numbers and then understand, like, you know, if you make a $150,000 gift, it's carrying a 10-month penalty period. That's where the loan comes in. You loan an equivalent value to the person that you made a gift to, so another $150,000, and then there's a note that's executed, right? Like just like a note in mortgage that you have on your house, that essentially requires the repayment of the loan over the next 10 months. And so what ends up happening is you're penalized for the gift that you made for 10 months, and then the loan covers that same 10-month penalty period, and at the end of the 10 months, Medicaid picks up the cost of your care. That's crisis planning. Sounds complicated. It is complicated. It requires the application to be denied, penalty periods to start, the loan to be repaid diligently by the person you're entrusting all of this money to, and you know, then ultimately, you know, fingers crossed, you're approved for Medicaid at the end. There's no other issues that arise between now and then, and it's successfully executed. So there's a lot that goes into these plans, and they're not inexpensive to effectuate. I mean, a good crisis plan could cost you $20,000, because ultimately, what is it doing? It's saving your family $150,000 to pass along to the next generation, right? And the complexity of those steps, being diligent about following every single one of them, that therein lies the pitfalls too of the crisis planning. And this is why I think that everyone should know that it's an option, but I don't think it should be the option that you're relying on, right? If you end up in this situation, okay, great. Reminder, I need to call an attorney who does this and find out, you know, what are my options now. But if you do advanced planning, then you don't have to rely on this option. Go ahead. So, advanced planning, you also have to understand how Medicaid is recovered, right? So, I mentioned at the outset about the estate and there being a 7-month creditor period. Okay? Medicaid is typically recovered through your estate. Okay. So when I talk about eliminating the need for an estate, right, and having no assets move through your estate, part of that strategy ties into long-term care planning. I'm talking about it because if you own a home, you pass away, you received Medicaid during your lifetime. After you've passed, when that home enters into your estate and it's sitting in its 7-month creditor period, the county and the state will make a claim against your estate for the equivalent value of services that they've paid for the cost of your care. So if you got $200,000 worth of services paid for by Medicaid for nursing home care, when that house is sold, the creditor, Medicaid, being a priority creditor, gets reimbursed from the sale of the house, the $200,000 that they paid out to you. They can also put a lien on your home during your lifetime. Now there are some exemptions, like for example, if you have a spouse that lives in the home, right? Like only one spouse is going into a nursing home. Then, you know, the Medicaid lien should be withheld, right? Not placed on the home to prevent that person from selling. Go ahead.
Does the spouse have to be on the deed?
Not necessarily, and actually some strategies would require changing deeds around, right? But what I think you're asking is like, if your spouse is not on your deed, is it subject to the lien? So the application for spouses, both spouses are applying, both spouses are attesting to the assets and resources. It can be owned by one spouse, but you have to think about what spousal relationship really is. It's a financial obligation to support the other in advance of the government, in advance of Medicaid. And so while they treat the house as exempt at the time of application, if you, the person who's staying in the home, passes away before the person who's in the nursing home, you have a problem, right? And same thing, you know, if you don't qualify for one of the exemptions, like whatever the circumstance may be, they can go ahead and place a lien on the home. Ontario County has now outsourced their lien recovery. And so they've hired a third-party company out of Texas with a joint effort through New York State, and they are soliciting information from Medicaid recipients who have lost spouses and or family members who might have inherited property. And unfortunately, some of what I'm seeing in practice doesn't actually even align with the Medicaid estate lien recovery rules. So it's all well and good what the rules are, but if the company that's enforcing the rules is actually not following them, we have a bigger problem here. And this is specific to Ontario County. It remains to be seen whether other counties like Monroe are going to jump on the bandwagon and also use this third-party company. But I have already had 2 instances of clients of mine that have come to me with their letters of recovery, and one who had an improperly placed lien on a home that was properly exempt at the time of the application. And so trying to navigate those after the lien has been placed without notice is really challenging. And so this is going to tie into the larger discussion about trust planning, right? But just a word for the wary, right? Because whether or not it's something that you own during your lifetime or it's something that moves through an estate, we may have a number of claims that are coming from the county and then attaching to real property if we don't take other action to protect that property. New York State, in its brilliance, also passed a new law that allows people to transfer their homes upon their death using a new tool called transfer on death deeds. This is supposed to be similar to like ladybird deeds that Florida has had. This just came through in July, and it was a surprise to everyone that this came through in terms of the budget. And even attorneys who have practiced in this area for decades, who are well tied into the Bar Association, the court systems, they didn't know that this legislation was coming through. And those that did know filed in opposition of this legislation being passed. And part of the reason for that is because while it seems like a really simple tool, it actually has a lot of negative consequences when it comes to long-term care planning, not on its face, but in terms of recovery. Basically giving New York State the ability to actually have a longer creditor period around anyone who uses a transfer on death deed. So, one step back, what is a transfer on death deed? It's a way to add a beneficiary to your real property, just like you would a retirement account or a life insurance policy or a bank account like I was talking about earlier. So someone who doesn't know any better, who just goes into the county clerk and picks up the form and fills it out, and it's a really simple one-page form, signs, the form and says, okay, I'm gonna name my, 3 children as the beneficiaries of my real property, and it's completely revocable. So if I change my mind next week and I only want to provide for one child, I can do that. I can revoke this transfer on death deed and file a new one, and it'll replace the last one. That sounds great. And it's not going to pass until I've passed away, so it has no effect whatsoever as long as I'm alive. I can sell the house if I want, right? It doesn't restrict me from being able to sell the house, so it seems like it's a really efficient tool. It's cost effective because, the county only makes you fill out this one piece of paper. You don't even have to fill out the more challenging, tricky forms that they make you fill out for a deed. And so people can go and fill this out without an attorney very easily, right? It says on the form, you may want to consult with a lawyer. Most people think about lawyers, they shudder and they're like, no. So, it seems like it's a really great option. But the problem with it is that the law that underlies this option allows for an 18-month creditor period. And it allows for a clawback into the estate if the estate was insolvent. And guess what? There's no clarity on exactly what that means. And so all of us in the estate planning and long-term care planning realm look at this legislation and we say, why would we file a transfer on death deed when the potential is that Medicaid as a priority creditor can open up someone's estate. Oh, it's non-existent, they don't have an estate. They, as any person, last available remedy, can open up an estate, claim it to be insolvent, and then take real property that's transferred according to one of these transfers on death deeds and pull it back into the estate to pay their claim. Sounds like a really great remedy for the county and the state to be paid. Have we seen it in practice yet? No, because it's too new. It's only a few months old in terms of legislation. So as we sat here, actually in Canandaigua, there was a joint section meeting for the New York State Bar Association between trust and estates attorneys and elder law attorneys. I kid you not, the entire room was rampant with questions, concerns. How is this going to be implemented? Why did they do it this way? How did we not know that this was coming? Right? It exists as an option. It's going to be talked about. It seems attractive. Don't do it without talking to an attorney. There are a few limited instances in which it might be acceptable. Go ahead.
So I did that transfer on death, like a year and a half ago, and it was filed, on the deed to real estate.
That sounds like you might have done something different.
It was
Because
through a lawyer.
and it might have been, for example, a deed reserving a life estate, because up until July of this year, this law didn't exist. So you could not have filed a transfer on death deed. And if you did it through an attorney, then I have greater confidence that it was appropriate for your situation, right? Because they would have looked at your situation and told you what the benefits were, and then explained, like, for example, you kept your STAR benefits, and your life estate carries a reduced value, but it has other implications, for example, from a capital gains tax perspective, like if you sell it during your lifetime, but there's still the step-up in basis at your death, right? Like a whole conversation like that most likely occurred when you sat down to do your paperwork. You're fine.
And what's the terminology of that one?
So that is a deed reserving a life estate. And that ties into some of the planning related to trust planning, and I'm going to touch upon that in another couple minutes too. I mentioned this specifically because this is just brand new, and it's blindsided everyone, and I just feel like there's just not enough information about it, because it's just very nuanced and subtle in how the recovery is actually going to occur. Other pitfalls is it doesn't allow for contingent beneficiaries, right? So if someone you've named, like the person who's supposed to receive, passes away before you, well then it doesn't work to pass it to anyone else. The title will vest automatically at your death, which could be a problem if someone who's receiving it receives any kind of government benefits, right? Like they have a resource-based government benefit that you don't know about. Or, for example, like they were applying to be a first-time home buyer, right? And suddenly you've passed away, now they have an interest in real property, they no longer qualify for their first-time home buyer grant through New York State, right? So like pitfalls in terms of title vesting automatically. And again, my cautionary tale here is just make sure you're talking to someone, a licensed practicing attorney who focuses on estate planning, right? To make sure that this is appropriate, because again, it's too easy to just go into the county clerk and file the paperwork and, make a mess.
At this point, from what you know about it, it is an option to file or not file.
Correct. Yes. Absolutely. It's optional. It's just something that someone might take it upon themselves to do, to think about, like, I want to make sure this home gets to my kids, so they go and they file this form, not understanding the implication about the creditor period that exists that's tied to it. That's right. Alright, so since you're not going to do that now that I've talked about that, without talking to an attorney, what are you going to do, right? And so this is the biggest part of the conversation, irrevocable trust plan. So earlier you had asked about living trust. This is where this comes in. And I say irrevocable. Irrevocable means unable to be changed, altered, amended, right? It's a permanent testamentary substitute, but even that has a little asterisk and a caveat to it because the law actually allows for irrevocable trusts to be revoked under certain circumstances. Most people think If they've already created a trust many years ago, they might have created a revocable trust. And that might have been done for estate tax reasons. It used to be in New York State, the estate tax threshold was $1 million, and that was much more readily attainable for a lot of people if you just had a life insurance policy, for example. And so maybe you even have a revocable trust that existed back then, but this is a little different than that, right? Because we're not worried about estate tax consequences in this situation. We're thinking about long-term care planning. So sometimes these are given different names, right? The concepts are all the same. I've heard them referred to as Medicaid Asset Protection Trusts, MAPT. The name, the terminology is the same. It's, what is it? It's an irrevocable trust, okay? And I find that this can be highly effective to protect non-exempt assets from Medicaid. And you can protect up to 100% if you want. Most people don't choose to fund 100% of their non-exempt assets into an irrevocable trust because there is a level at which you are relinquishing control over your assets. But you can most certainly think about your probate and non-probate assets and identify, for example, your home, which is most likely to be a probate asset, and then think about funding it into this trust, protecting its value in there. And I think that's where it's really highly effective because it eliminates the need for probate around real estate. It preserves your STAR benefits, which is great because you don't have to lose your STAR just because you're funding it into a trust. And it preserves the step up in basis, which is basically what the IRS allows if you've passed away owning an asset in your individual name, that there's not going to be a capital gains tax implication for the next generation, for as long as the IRS allows that. What actually happens in practice is a deed transfer to the trustee of the trust. So you create this trust, you sign the trust form, and then you also effectuate the deed being transferred from your individual name to the name of the trustee of the trust, and in that way, the title of the property passes into this trust. But this trust is for your benefit during your lifetime, right? So things can happen in this trust, like it doesn't have to stay in its original form. The real estate could be sold, or it could be leased. New real estate could be purchased, right? So there are options for changing the form of the trust asset in the trust. And oftentimes people ask me, okay, well, what's the benefit of doing this over, for example, the deed transfer reserving a life estate? And then we talk about, well, the pitfalls that inevitably happen with people and their lives, which is namely your children and the things they don't tell you about, creditors, bankruptcy, divorce, right? So if your children have creditors that you don't know about, by putting it into an irrevocable trust, those creditors are not attaching to your real property during your lifetime. That's important. You don't want to have their judgment creditors automatically attaching to your real property while you're still living in it. Bankruptcy, if they need to file for bankruptcy, this is not an asset that they own, right? It's owned by the trust. And so in that way, it's protected. Same thing with divorce, right? So, you know, they again do not own this asset. It is in trust for your benefit during your lifetime, and so thus it's protected. And then just to think about this a little bit further, like what's actually happening? So we're doing this advanced planning to run the look back period, that 5-year period of time, right? So if we're thinking about this, we want to make sure we have enough time to effectuate the strategy, or we have a contingency plan. That's key. We need third-party trustee involvement. And this is really just a standard of practice nowadays, that you would name, for example, one of your adult children to be the trustee of this trust, right? And so what it's relinquishing control over is your management of that asset and giving that control over to the trustee. And then the trustee is then responsible for making sure that that's operating in your best interest, right? Like if the house needs to be sold or rented, or, you know, a new house needs to be purchased. They also have to follow the terms of the trust, and these are probably the next two critical pieces to this. We have a restriction on access to principal. Okay, so immediately people are like, what is principal? So with real estate, principal would be the equity that you have in your home, right? So if your home is worth $300,000 and you have no mortgage on it, then you have $300,000 worth of principal in the trust. So you can't take that money back out. All right, most people who own their own home aren't taking money back out of it unless you have a home equity line of credit. So that's the only place that I caution people could inadvertently, really break a trust that's just funded with real estate. It's different if it's funded with liquid dollars, but the restriction is the same. Like, you can't pull money back out of the trust directly for your care. Does that mean that you are, locking it away under, safe and key and then you're never gonna have access to it? Technically, no. We also have a safety mechanism for allowing adult children to be able to access those funds. They just can't give you the money back directly. Again, we're thinking about that long-term care planning. And from a really practical standpoint, even if we were gonna do this, that's the payment of last resort. We wanna look to all your other resources that are non-exempt and spend them down first.
This is a Kodak, this happened to a family, and I was responsible along with the bosses, and it
You-
was not easy.
You are right that it has happened in our community.
Right.
I have even seen it in my own practice where, there has been simultaneous deaths of couples, right? So this is not so far-fetched, it's law school textbook. This does happen in practice. I've seen it in my 10 years. So yes, I think it's good to create plans, but everybody's got a different level of planning that they do. So we create contingencies, we plan for the worst, hope for the best.
Yes, can you define, what gifts are considered in that 5-year look-back period? And when you talk about, gifts, beyond real estate and just liquid assets, are there other gifts that have to be
So technically,
considered?
everything, right? Like, it doesn't matter if you gave a gift card or you gave presents, but those are a lot harder to track. And usually what Medicaid is looking, what the county looks at are cash withdrawals in excess of $1,000 from your accounts. And so if there are routine cash withdrawals in excess of $1,000, they're asking, where did that $1,000 go? I once had a Medicaid application where, the client paid for their taxes in cash. So every September, they went and they took $4,000 or $5,000 out of their bank account. We could easily, closely in time, point that to the taxes, right? Because look, here was their cash withdrawal. Here was the tax bill that shows a receipt of being paid on this date. Just a few days transpired, that's not a gift, right? But a lot of people who operate on a cash basis end up getting caught in that problem. So it can be tricky, because technically gifts are anything that you give.
Follow up on the 529th, just to make sure that I'm understanding this. Theoretically, then, during the 5-year look back, that money can be clawed back,
It's penalized, yes.
so in effect, that college student,
Not clawed back. That college student gets their fund.
okay,
You personally, as the applicant, are penalized an equivalent dollar amount, meaning you have to privately pay for your care.
all right, so that's where it hits.
Correct.
So that in effect, if it was $500, now, if the estate doesn't have that money available
This is
for the individual.
during your
nursing
lifetime.
home
Yep.
Doesn't have that money available?
So then that makes for the tricky part. How is that nursing home bill paid before that period of time before you qualify for Medicaid? Right? So that's where the rubber meets the road in doing the planning and understanding the implication of gifts, where money's coming from, and how much more planning we can do. So if you're making gifts now and that's the only thing you're doing, that's a piece to the plan, just understanding its implications, right? And there are advantages to forward funding 529s, in excess of the annual exclusion amount at one point. And I believe this is still the case, I haven't looked at it recently, but that you could snowball 5 years worth of 529 funding in one go. Okay, well then that's how you only do one go and then run a 5-year clock from that snowball. So that might be an efficient option too.
Can you be the second trustee?
Me as an attorney,
No, me.
you you as an individual. No, you can't. And here's the thing, because if you are the trustee of your own irrevocable trust, you're in control. And what Medicaid is trying to do is constantly find ways to, chip away at the trust planning. Nothing is guaranteed, right? So like you do the planning, the rules can change, and the trust planning may not work in time. Like that's a reality to doing long-term care planning. The rules are evolving literally on a monthly basis as new rules come out, and there are fair hearing decisions that are being had with contested applications. And then at the same time, like the rules are updated, by New York State on a more regular basis. And they're looking at this recovery piece, right? That's those transfer on death deeds where that 18-month creditor period came from, There's a piece to the recovery where the state's looking at the program and they're saying this program is insolvent. If we keep paying out dollars at this rate, it's not gonna work. And so they're looking at, recovery. So to the extent that like if you are your own trustee and you can control what happens with that trust, that doesn't work. So usually we try to create an order of succession, a primary and then at least one alternate, or a primary and two alternates if we can. And I think you have another question too.
Besides the documents that we talked about this morning that are needed as part of the state plan, during a 5-year look-back period, what additional documents are needed?
Usually none, because what's happening is basically it's like we're funding the trust and then we're setting the trust aside and it just exists. And then if there's some intervening event, like a health event or, something else that happens, then you pick up the phone and we look at what the scenario is, we talk about it, we make a contingency plan if we need one, right, and we adjust.
Could you clarify when you talk about the $1,000 and say that if you were doing cash withdrawals, they would be looking at that versus the $18,000 gift thing, how, in terms of how those are different?
They're really not different, they're the same. What I've identified is that usually about $1,000 is where the questions come on the Medicaid application for cash withdrawals. Meaning, like if you go to the bank and you only take out like $100 here or $200 there, like most people would attribute that to regular daily expenses, right? They're not normally questioning those lower dollar amounts. But when the dollar amounts exceed $1,000, that's usually where Medicaid will push back on an application, and it's really the Department of Social Services, and it's county by county. So it also turns on the county in which you're applying. I've seen very different rules apply in Monroe County versus Ontario County, simply because of the size between the two. So when they look at an application and the caseworker is going through and reviewing the statements, they're required to flag what they believe could be potential gifts to create the penalty period. And in doing so, they give, a letter that says, please provide checks for, these transactions, or please provide explanations for these transactions. But I've had crazy things that have happened where I had a client who sold his mother's coin collection and then deposited the funds in the bank account, right? Like the opposite of what we're talking about. And then Medicaid came back and were like, where did this $4,000 come from? He was like, I cashed in mom's coin account. Okay, this is more money for you. Why are you asking me about this? But it's basically their prerogative which transactions they're gonna flag, and then you have to provide the explanation.
Okay, my other question is, what about, say you own a home and you have renovations, there are some that you might be doing modifications. There are other things where you're simply trying to spend your money like add a sunroom rather than grab bars. So how do you look at that?
That's a great question. That depends on the county and the caseworker. So the trust, or even your life estate deed, has language typically in it that says that the person has the requirement to do maintenance and upkeep. Okay, well what's maintenance and upkeep? Well, if you need a new roof, right? You've got to put a new roof on the house, then that's maintenance and upkeep. Is the sunroom maintenance and upkeep? That's a little bit of a stretch, but maybe you really need that sunroom for some other reason, right? And so ultimately it's your discretion and risk level of how far you're willing to push it with your maintenance and upkeep budget, knowing full well that if you spend $90,000 on, expanding the foundation of your home and then putting on a sunroom, probably gonna get a few more questions about your renovation than you would if you just put a roof on, right? So it all turns on your level of comfort. Some people are more comfortable pushing the envelope and others are much more conservative and say, no, we're just gonna stick to what we know.
What other types of assets can be protected in the kind of trust you're talking about today, besides real estate?
Sure, technically anything that's non-exempt for Medicaid application, right? So really, what is an exempt asset? We talk about retirement benefits like IRAs, 403Bs. Those types of plans are treated as exempt because they're treated as income for the application. So if you wanted to fund, the trust with like a whole life insurance policy by changing the title owner, you could do that. If you wanted to fund vehicles, you could do that. But there's just complexities that come with some of the other assets that get funded into trusts. And like most people would think, instead of just those little things, they'll think about like liquid dollars, like a brokerage account being retitled in the name of a trust, and that's permissible. But then it's not, an investment in terms of like income coming to you, and we need to think about income tax consequences and how that's actually gonna play out. Especially if you have no access to the principal, right? You're relinquishing control, right? So I find like for most people, the real estate is a really easy place for them to relinquish control, fund the trust, and feel comfortable that they're protecting an asset that otherwise would move through probate, right? And leaving them the brokerage account that they have so that they can use that money for their care. But the funding is much broader than I've described, yes.
The asset being a 401k, that transfers, the recipient is responsible for the 10%. How does that compare with possibly transferring it to a Roth IRA with a 10% taxes?
You're talking about different strategies, you're talking about tax planning strategies, not long-term care planning strategies, because your 401k is exempt either way. Yes. So from a long-term care planning standpoint, your 401k that's generating a required minimum distribution is exempt. When you convert it to a Roth, it's no longer exempt because there's no required minimum distribution on a Roth. So you've taken an exempt resource as a 401k and then converted it into an available resource. And the reason that you're likely thinking about that is your tax bracket planning. This is what financial advisors are really great at, right? Like they look at your tax bracket and they say, okay, you're in the lowest tax bracket, but your children are going to be in the highest tax bracket. If you maximize your bracket every year, you're converting, and taking out those pre-tax dollars and moving them to post-tax dollars. There's a place for that planning, yes. It just changes what happens here. You're taking an exempt asset, resource, and then converting it into a non-exempt resource because of the change in the required minimum distribution. It can't be treated as income in a Roth. Okay. All right. I think I've got everyone's questions. If you have more, you're welcome to come visit our office, meet with me individually. We offer free initial consultations, and we're really, just down the road, right? We're on 5 and 20 in the original built schoolhouse for the town of Holdwell. It's a very sweet little place. There's parking right in front, so you don't have to deal with City of Canandaigua parking, which is probably my single favorite thing about the space. But it's really incredible to come and meet with us. If you need any kind of handicap accessibilities, we do have a ramp. So even it's wheelchair accessible for our clients, we just need to know in advance. So just let us know that when you call, and we'll make sure that you can get it. And that's just a map of where we're located, just past CNET. And the last slide will have our contact information, and you can reach at the top of the questionnaire. It's there as well for you. All right, thank you so much.
Thank you, Christine. That was very informative. Thank you everyone for coming. Reach out to Christine if you have further questions.